We often see cases in which employers force employees to do certain tasks or work off the clock. For example, it's common for workers in the call center industry to have to spend some time at the beginning of their shifts setting up and logging into programs before they clock in. And that's a violation even if it only involves a few minutes a day. And those minutes add up by day and by worker and can result in some very large liabilities for employers. We've also seen a lot of employers in settings like factories, logistics facilities, healthcare facilities, in which workers are subject to rounding policies, meal deduction policies, and these result in the workers not being paid for time spent doing stuff like setting up workstations, or perhaps not being paid for work performed through their unpaid meal breaks. Other violations involve employee misclassification. So misclassification can mean labeling a worker as an independent contractor despite controlling them enough that they should really be labeled as an employee. It can also mean classifying somebody as a salaried manager, let's say, despite the fact that they don't primarily do managerial duties, in which case they would have to be paid overtime either way. The employer can't say, well, you agreed to be paid a salary, you can't get overtime. The rights to be free from these violations are employees can't waive them by signing contracts or by agreeing to certain things. So we often see cases of misclassification where the employer says, well, this employee agreed to be an independent contractor, agreed to a salary, but the classification is improper and unlawful. And so in those cases, the employee has the right to go back and claim the money that they should have been paid had the employer complied from the get-go. Well, I think the employees have to recognize that what's going on, if you see a violation, it's not your fault. The employer may try to make you think it's your fault. They'll say, you agreed to be paid this way, you agreed to work here, you certified that your timesheets were accurate, you can't now claim that you were working off the clock. So employees should understand that even in cases like that, they still may have rights, and they shouldn't just throw in the towel just because their employer is trying to blame them for the issue. If you suspect that your rights are being violated and want to make sure your employer is being held accountable, you should raise the issue with the employer in writing and keep records of all the correspondence. In some cases, your complaints may lead to the employer resolving the issue or getting into the hands of the right person, such as an HR personnel if your company has one. And if the company remains unsolved, your complaints could help prove that the company was aware that they were violating the law. Another tactic employers often use is to claim that employees are lying about the hours they worked or inflating the hours they worked. And employees can counter this by keeping detailed records of their work. The more detailed, the more contemporaneous they are, the better. The employer is required to keep your records, but in many cases they don't do so properly, or they don't include all of your work within their records. So employees have the option, and it may vary depending on what kind of work they do, but if you can keep records, it does end up helping your ability to prove your case if it gets to that point. And it's also, employees should keep in mind that sometimes records are kept automatically. If they're carrying a phone around, that phone might have information that can then later be used as a record, either that a communication was had, or it might show where their GPS location was, or what location they were at a certain time. All that information can become crucial in a wage and hour lawsuit where the employer is disputing what hours were worked and what work was performed. Well, I think that you should worry about it. If you believe your rights are being violated, you should do something about it. And the first thing to do is find an attorney that you're comfortable working with. And there are many, our firm is one example, but there's many attorneys who are very focused on wage and hour cases, very knowledgeable about wage and hour law, and they most often, as we do, work on contingency retainer agreements, which means that you as the employer are not paying anything up front to the law firm. And law firms only make money if the case is successful, meaning it results in a settlement or a judgment, or let's say an arbitration award. We'll talk about that. in those cases, the employer will not only owe you, the employee, money that they should have paid you from the start, but they'll also owe the attorneys their fees and costs. The employee doesn't have to pay it, the employer does. So you shouldn't be deterred by having to pay legal fees, because most often you will not. And so once we have a new client, we often try to determine, make sure we understand what the violation is just in general terms. And we often try to assess where would this need to be filed, right? Sometimes we find a violation against an employer that is already the subject of a lawsuit in court. And if that's the case, you as the employee may be able to simply join that already existing case and become part of it quickly without having to take the lead or without having to put your name on the papers. Other times we find that employers have made their employees sign arbitration agreements. And in that case, instead of filing a complaint in court, we'll file the complaint in an arbitrator forum where a private attorney decides the case based on the evidence. We handle a lot of cases like that, but primarily what we handle is cases that are filed in federal court. And these can be lawsuits, just one person suing a company to recover wages, or it can be what's called a collective action lawsuit or a class action lawsuit, where many employees are essentially suing the same employer in the same court before the same judge for the same violation or violations. And we strive to understand, as soon as we start representing a client, what is the best way to get the best value out of their claim. And until the case is actually filed in court, your employer does not know that you have an attorney. So we often have clients who are maybe hesitant to sign up with an attorney because they don't want their employer to find out about it. And you should understand that that's no reason not to speak with an attorney. Your conversations with an attorney are confidential. Our firm does not go and tell your employer that you've signed up with us. Typically they won't find out until after you've filed a claim. And once they do find out, it's unlawful for them to retaliate against you as well. So, and our firm has in past cases assisted employees with protecting them from retaliation as well. So if you are going through this process, it's important to make sure your attorney is aware of any suspected retaliation that you face at any time during the process. But in our experience, employers are aware of the serious consequences that can follow from retaliation. It's fortunately a rare occurrence in our experience. Well, the Fair Labor Standards Act says at the nationwide level what is and is not a wage and hour violation. And what it basically says is a wage and hour violation to pay an employee less than the minimum wage, which is $7.25 per hour on the federal level, and that it's a violation to have an employee work over 40 hours in a week and not pay them time and a half for each of those hours over 40 at an overtime rate of time and a half. The FLSA also says that if an employer violates those basic requirements, they can't show that the employee was exempt, which in many cases they can't, then the employer can be ordered by a federal court to pay the employee the amount of wages that they should have received from the start had their employer paid them properly under the law. They're also entitled to double that amount by recovering what's called liquidated damages. So liquidated damages will be the same amount as you're found to be owed for wages. And that's meant to compensate you as the employee for the time that you've been forced to wait to recover this money. So that's kind of like a form of interest, you could think of it. But that's something that the FLSA provides to employees to help make sure they're made whole when their rights are violated. Another kind of, the FLSA also says that the attorneys who represent the employees can recover from the employer their attorney's fees and costs. So that protects the workers in being able to have attorneys represent them without having to pay those attorneys. And then there's also the ability under the FLSA to be part of a collective action where many workers join the same case. And for many workers, this can reduce the amount of time and expense that he or she must undergo as part of being a plaintiff in a lawsuit. Sometimes the plaintiffs can delegate certain responsibilities in the lawsuit to certain plaintiffs, such as determining whether to settle the case, whereas hundreds of other workers can be in the case and part of it and eligible to recover from it, but don't have to take a lead role. And for many workers, that's an appealing option because they have jobs currently that they're busy with, or they don't want to be the face of the lawsuit. So the FLSA allows them to be part of it without being the face. Well, the FLSA has civil penalties and criminal penalties. Our firm can only handle the civil aspects of the FLSA. And so the penalties that we can recover in a lawsuit that where we're representing an employee would be the amount of wages they're owed, which is essentially what they would have been paid had their employer paid them in accordance with the FLSA. The penalty would also include the liquidated damages that they're owed, which is doubling their recovery. And the employer would also have to pay the attorney's fees and costs of the firm representing the employee if they're successful. And that can be quite expensive for an employer too. And so from the civil side, and that's before you consider what the employer has to pay to their own attorneys too, and what they have to pay. Let's say if it's an arbitration, the employer might have to pay the arbitrator, and all that can add up to hundreds of thousands of dollars, even millions of dollars. And so many employers look at that, and it makes them want to comply with the FLSA because they want to avoid the headache and honestly the major financial threat a wage and hour lawsuit can pose.